Hello everyone and welcome to part B of part 3 of this series. Let's not waste any time in continuing on from where we left off last time with section G4, title and identity. Clause 1. Unless condition G4.2 applies, the buyer accepts the title of the seller of the lot at the contract date and may raise no requisition, no objection to any of the documents that are made available before the auction or any other matter except one that occurs after the contract date. Clause 2. The following provisions only apply to any of the following documents available that are not made available before the auction. A. If the lot is registered and the seller is to give the buyer within 5 business days of the contract date an official copy of the entries on the register, the title plan, and where noted on the register of all documents subject to which the lot is being sold. B. If the title is in course of registration, title is to consist of I. Certified copies of the application for registration of the title made to the land registry and of the documents accompanying that application. I2. Evidence that all applicable stamp duty and land tax relating to that application has been paid. 3I. A letter under which the seller or its conveyancer agrees to use all reasonable endeavours to answer any requisitions raised by the land registry and to instruct the land registry to send the completed documents to the buyer. C. The buyer has no right to object or make requisitions on any title information more than 7 business days after that information has been given to the buyer. Clause 3. Unless otherwise stated in the special conditions, the seller does so with full title guarantee except that A. The covenants set out in the law in Section 3 of the Law of Property Act 1994, miscellaneous provisions, shall not extend to matters recorded in registers open to public inspection. This is to be treated as within the actual knowledge of the buyer, and B. The covenants set out in Section 4.1b of the above mentioned Act of 1994 shall not extend to any condition or tenant's obligation relating to the state or condition of the lot where it is leasehold property. Clause 4. The transfer is to have effect as soon as if expressly subject to all matters subject to which the lot is sold under the contract. Clause 5. The seller does not have to produce, nor may the buyer object to or make a requisition in relation to any prior or superior title, even if it is referred to within the documents. Clause 6. The seller, and if relevant the buyer, must produce to each other such confirmation of all evidence of their identity and that of their mortgagees and attorneys, if any, and as is necessary for the other to be able to comply with the applicable money laundering regulations and land registry rules. Moving on to section G5, the transfer. Right, so clause 1, unless a transfer method is prescribed by the special conditions, then A. The buyer must supply a draft transfer to the seller at least 10 business days before the agreed upon completion date, and the engrossment, signed as a deed by the buyer if condition G5.2 applies, 5 business days before that date, or, if later, 2 business days after the draft has been approved by the seller, and B. The seller must approve or revise the draft transfer within 5 business days of receiving it from the buyer. Clause 2. If the buyer has any liability other than to the buyer in relation to the lot or a tenancy following completion, the buyer is specifically to covenant in the transfer to indemnify the seller against that liability. Clause 3. The seller cannot be required to transfer the lot to anyone other than the buyer by more than one transfer. Clause 4. Where the special conditions state that the seller is to grant a new lease to the buyer, A. The conditions are to be read so that the transfer refers to the new lease, the seller, the proposed landlord, and the buyer to the proposed tenant. B. The form of new lease is that prescribed by the special conditions, and C. The seller is to produce at least 5 business days before the agreed upon completion date the engrossed counterpart lease, which the buyer is to sign and deliver to the seller on completion. And on to the last section for this video, G6, completion. Clause 1. Completion is to take place at the offices of the seller's conveyancer or where the seller may reasonably require, on the agreed upon completion date. The seller can only be required to complete on a business day between the hours of 9:30 a.m. and 5 p.m. Clause 2. The amount payable on completion is the balance of the price adjusted to take account of apportionments plus, if applicable, VAT, and interest, but no other amounts unless specified in the special conditions. Clause 3, payment is to be made in pounds sterling and only by A, direct transfer from the buyer's conveyancer to the sellers, B, the release of any deposit held by a stakeholder or in such other manner as the seller's conveyancer agrees. Alright, clause 4, unless the buyer and the seller otherwise agree, completion cannot take place until both have complied with the obligations under the contract that they are obliged to comply with prior to completion. And the amount payable on the completion is unconditionally received in the seller's conveyancer's client account or otherwise required by terms of the contract. Clause 5, if completion takes place after 1,400 hours for a reason other than the seller's default, it is to be treated for the purposes of apportionment and calculating interest as if it had taken place on the next business day. Clause 6, where applicable, the contract remains in force following completion. And that ends this video. Join us next time where I will try and get the remainder of this legal documentation done, and have a good day, everyone.